Hello guys, this once again is Samuel Odhiambo Otieno, who is a senior law student at JKUAT, Current Campus, Nairobi, Kenya. And I would once again like to welcome you all to the Samuel Law Podcast and Academy YouTube practice. Welcome. Today, in this lesson, we are going to look at yet another element of contract, and this is formalities. And our objective today is that after learning this, we are going to understand the different types of formalities that can be used to make a contract enforceable. We are also going to identify the different types of contracts that require certain formalities for them to be binding. We are going to understand why some contracts must be made by deed, and also learn about the contracts that must be in writing and those that must be evidenced in writing. So let's begin with our introduction. According to the general rule of contract law, an agreement does not have to be in a written form for the contract to be deemed as binding. In fact, many contracts are simply done orally, which does not invalidate them in any way, but their only disadvantage is that in case of a disagreement, parties do find it quite difficult to prove their case. And that's why most complex transactions are always made in writing, which helps the parties a great deal to prove their cases in case of a dispute. Even though many contracts do not need any formalities for them to be binding, there are some types of contracts which do require certain formalities to be followed to make them enforceable. These can be classified into three groups, which are 1. Those which must be made by deed, 2. Those which must be in writing, and then 3. Those which have to be evidenced in writing. So let's begin with the first one, contracts which must be made by deed. This basically means to put into a formal document and sign before witnesses. And they include a contract for a lease of property of 3 years and above under the Law of Property Act of 1925. A deed may also be used as a way of making binding what would otherwise be a gratuitous promise without the need for a consideration from the other party. What about contracts which must be in writing? These are laid down by some statutes, and they include those that involve the transfer of shares in a limited company. That's according to Companies Act of 1985. We also have bills of exchange, checks, and promissory notes, according to the Bills of Exchange Act of 1882. We have regulated consumer credit agreements such as hire purchase contracts, Consumer Credit Act of 1974. And then finally we have contracts for the sale or disposition of an interest in land under the Law of Property Miscellaneous Provisions Act of 1989. Let's look at those which must be evidenced in writing. Evidenced in writing simply means that although the contract itself need not be in writing, there must be at least some written evidence of the transaction, which must have existed before one party tried to enforce the contract against the other, and which must be signed by the party against whom the contract is to be enforced. And examples here include contracts of guarantee, where one party guarantees the obligation of another. That's according to the Statutes of Frauds of 1677, and also contracts for the sale or disposition of an interest in land prior to the Law of Property Miscellaneous Provisions Act of 1989. So let's have a recap of this. In this lesson 6 of Module 4, we've been able to identify the different types of contracts which require certain formalities to be followed for them to be binding. We've also been able to identify the different types of formalities necessary to make a contract binding, and understand the contracts which must be made by deed, identify the contracts which must be in writing, and finally learn about those contracts which must be evidenced in writing. Do you have any questions or comments? Please kindly post them in the comment section below the video. Otherwise, thanks for watching this video. Please remember to subscribe to my YouTube channel, like the video, click the notification bell, and share with your friends and family or networks. Thank you.